Commissioners and the Planning Commission. So just a few things to get started today. If I could ask for both entities to call their respective meetings to order, and we'll start with the Board of Commissioners.
All right, good evening. It is my pleasure to call our joint training session for the Board of Commissioners and the Planning Commission to order.
And Chairman Peterson, if you could do the same for the Planning Commission.
Okay, for the Planning Commission, I call the joint training session to order.
Thank you so much. So tonight we will have Ted Meeker, who is an attorney who's done a lot of work with us and also around the Metro Atlanta area as it relates to land use and zoning and other local government matters. So I will turn this over to him. So Mr. Meeker.
Good evening.
Good evening.
Good
It's
evening.
nice to meet this group. Of course, commissioners, I've dealt with both of you at least a few times.
Yes.
I always tell the anecdotal story. My first year of law school, I clerked for a firm down in Miami, Florida, and did nothing but medical malpractice defense the entire summer. And it was so exciting. And I thought, that's what I want to do when I got out of law school. And somebody told me along the way that you're going to wind up doing whatever gets on your desk your first day at your law firm. And I was working for a zoning and land use lawyer. And I was like, here, I need you to dig into this. So here I am, having practiced law for 33 years, doing a training tonight in Rockdale County. But thanks for allowing me to be here and to participate. I'm going to try to do what I always avoid, or let's try to avoid, and that is I'm not in a courtroom, so I'm going to try not to sound like a lawyer. If at any time I start saying things that sound like I'm arguing to a judge rather than talking to people, raise your hand and say, quit talking like a lawyer. You won't offend me. I can promise all of you about that, okay? I'm going to kind of give everybody a little bit of an overview, and then I'm going to dig into some of the nuts and bolts. We've had a presentation. Staff has been great to assist me in making sure I covered what they wanted me to cover. I sort of have nuts and bolts that I always cover anytime I do this. And now the question is, can Ted operate the clicker? Look at that. Okay.
Ted, may I ask you this? I think for our PR department, we're getting feedback, a lot of feedback.
Yes.
And I'm standing back away from the microphone.
I'm not.
So I think that, and I'll go talk to PR in just a moment, we have Commissioner Smith who is participating virtually tonight, so I'm not sure if that's the Zoom, but let me just go check, and please go ahead.
And to clarify, on Zoom, do we have more than one computer connected or phone?
Just one.
Okay.
Yeah. So let me go check on that,
All
and
right.
please resume.
Thank you. Go
I
ahead.
think it's fine. If they mute it, I think it's fine.
I'm going to, again, try to stand back where I don't reverb too bad. In essence, when you're considering a zoning matter, for the Planning Commission members, your situation is typically what we call legislative. That's voting to rezone a piece of property, although you're making recommendations rather than voting. Rezone a piece of property, text amendments to the ordinance, and you're reviewing special use permits. There's also something that Georgia law calls quasi-judicial. Now that is exactly what it sounds like. That means you're acting sort of like a judge. And that typically would come into conditional permits that you will review and consider and make recommendations on. Conditional permits by their nature sort of have a set of criteria. You either meet them or you don't. And if you don't,
So that's my cue to interrupt one more time. I apologize, Mr. Meeker. So we have the feedback handled, and you can come as close to the microphone as you can now. So,
They
okay,
tend to
great.
be
Thank
loud,
you.
So if I get too close to the microphone, I'm going to hurt somebody's ears.
Absolutely. So we're
In any
good.
event, so with the conditional permits, again, you're acting like judges. And I'm going to tell you that you need to know the difference, and I'm going to elaborate why as we go through this process. I will tell you that over here is the future land use map. This is a part of your comprehensive plan, or the county's adopted comprehensive plan. This is the last time the county updated its comprehensive plan and future land use. This is how the county said we want to develop going forward. Now, the one thing about, is that my phone? I bet it's my
That
phone.
might
I'm
that might be
sorry.
your phone.
In any event, ignore it. Fine. So the future land use map is sort of, think of it as a blueprint. This is what we want to be when we grow up, okay? I've had conversations, because there was a recent zoning that people were very upset about. and it was to a commercial classification. And when the lawsuit got filed and I dug into the future land use map, what did it say that it was supposed to be zoned? Commercial. Kind of makes it hard to defend when somebody's asking for how we've said we want it to develop. So that's where something you really should, staff will always analyze it. I've never seen staff produce a report that didn't talk about what the future land use map or what the future designation was going to be. The other thing you'll see on the future land use map are what they call character areas. Each area sort of its own little built-in stuff. You might have commercial nodes, you might have industrial areas, you might have high-density residential areas, you may have low-density. Sometimes you sort of put all of those uses, typically not industrial, but some commercial, some low-density residential, some high-density residential, and it sort of forms its own community area as a part of the overall picture. As I always tell people, commissioners are a continuum. We refer to them as the Board of Commissioners, but obviously the people in those seats change over the course of time. So that means when you come into office, if you don't like what this future land use map says, guess what you can do? Amend it. You can take a look at it. Now, there's a time period that we have to look at our comprehensive plan and our future land use map. And of course, staff does that in the normal course of business, and so does the county. But it doesn't stop anybody from looking at the future land use map and saying, I'm not sure I like that. I can tell you, we just actually did that as staff went through that exercise. Like, okay, we have this situation come up. Are there any more time bombs waiting to go off, so to speak? Yes.
How often does it need to be reviewed? Because you mentioned every time.
Is it every 10 years? How often does comp plan get reviewed? I'm trying to remember, to be honest with you. Every 10 years.
And that's per, is that per statute, like the
It's,
state? or
Georgia
is
law
that per-
required, and DCA requires it to be reviewed and updated every 10 years.
And when was the last time this one was done?
So, Madam Chair and all the other participants, so we are streaming. So I know we had a little bit of feedback to begin with, but anyone speaking, please speak into the microphone. We're getting that some folks can't hear, so, okay.
Staff believes it was last updated in 2023.
Okay.
As I mentioned earlier on, it's challenging if the county says we're going to deny a rezoning of property and it indicated that it's supposed to be what the applicant was seeking. Obviously, that can be a challenging defense if we wind up in a court. Because typically, when I've had that happen, the judge looks and says, well, weren't they trying to do exactly what your comprehensive said it was supposed to do? It's a hard thing to overcome. Not impossible, but hard. You, of course, have zoning hearings. Y'all have public hearings probably on virtually everything that you have to consider. And both entities do that on a regular basis. Zoning actions under Georgia law are kind of what I said earlier. Adopting a text amendment to your zoning ordinance, which means, okay, we have general commercial.
Speak in the microphone.
I'm sorry.
And can you ask PR if we have a mic that he can wear to
That's
mute?
what we-
Okay, great.
Yep.
We don't have one. He said we could just turn it like this. So if we go over there, we'll just turn it.
Okay. How about if I just try to stand at the podium a little bit better?
I think
Does your
so.
clicker have a little
I don't think it's
laser
gonna work any other way.
I'm just wondering. 'Cause, I mean, 'cause-
It does.
Yeah, because I know it just seems like you want to kind of get closer to the map and show us, but you maybe use the
My father used to say, and I think it's because I'm half Italian, that I can't talk and stand still or sit down.
Well, I mean, I like to like.
I have to be
more expressive. I
constantly
think that's more
moving.
engaging,
It's,
what
yeah,
you're
it's
doing,
an
so.
admitted fault, but I'm going to do better at staying at the
Right.
podium for right
And
now.
we will
'cause it-
say that the podium can move.
The podium can move, the maps can move, we can move.
That's
So,
right.
I think I'm
you
going to
tell
be
us what you
okay.
want.
I think it's time that I plant my feet for a second.
Let's see if I can move the map.
Just a little.
No,
closer.
I think it's more importantly that they can see him. So yeah, as long as they can see him.
Yeah, we can see.
Oh,
More engaging.
Yeah.
If you're closer and showing us what you're talking about.
I think the visuals always help, so.
Right.
we are adjusting on the fly.
Zoning on one side and future land use on the other.
Now you're really hemming me in. Okay, zoning actions. amending the text. For example, you have 20 uses allowed in your commercial district. You want to add a 21st use. That's called a text amendment. You want to limit certain things that were in there, remove certain uses. That's a text amendment. Obviously, a zoning map amendment is when you're changing the designation on a particular parcel. And then, of course, special use permits, which are defined in the UDO. There are certain uses that you can obtain a permit, but you don't have the right to do them automatically. You have to get permission, so to speak. And they're a little bit different than conditional use permits. I don't know why it is like that. It's just how they've been defined over the years. As I mentioned earlier before, in a zoning case, map amendment, text amendment, special use permit, it's really important. For the Planning Commission members, you're never going to be called to testify. You're not making the final decision. Fortunately for the commissioners, in a true rezoning of property case or a text amendment, they can inquire into each legislator's motive for why they voted on a particular way. That's a nice benefit. The reason being, one commissioner might have said no for one reason, another commissioner said no for a different reason, and the third commissioner said no for an even different reason than the first two. Ultimately, the answer was no, but everybody has their own reasons. Sometimes they're shared, sometimes they're different. When you go to court, it's like what happened before the Board of Commissioners never even happened. It's, again, you're starting over. It's legal phrase de novo, means you're beginning anew. So when you go to court, yeah, everybody knows that the commissioners turned that one down, but you have to go through, they have to prove why they're entitled to it, and we have to say why they're not. The duties of the Board of Commissioner, and this is, again, I've sort of copied and pasted from the UDO. I think you all had a handout. Do you have a question?
And that's just back to what you, just to clarify some things, you know, it's starting anew. It's still important for us to articulate why we are maybe denying something.
You can, but I don't always get that worked up if they haven't.
Okay.
Yeah, in zoning. Now, we'll talk about items called variances or conditional use permits a little bit later.
Okay.
And those, I think, is a little bit more important because it's what we call it's on the record. In other words, if we go to court to try to defend what the action that the county took, then it's based on the minutes and all the documents and the transcript of the public hearing and I have to be able to point to evidence in that record to justify why the county took the action it did. But for the legislative stuff, the only hang-up I've had on a matter in recent memory was a case where a special use permit had been granted and there was really no evidence in the record to support per se that decision. And by that I meant that the staff did analysis based on the criteria for rezoning. There was no independent analysis of the criteria for the special use permit. That, and we had a judge that just didn't want to go our way. It happens sometimes. But nonetheless, in that instance, it's a little bit more important, and we'll talk about that in a little bit. But fortunately for the planning board, you're really not going to get into too many quasi-judicial issues. So that's the good news. We have a separate board that does that. That's not part of the training. It's in the materials, but it's more for information purposes. In any event, duties of the Board of Commissioners, we'll work through yours. Obviously, you're going to make recommendations receiving from the department. As commissioners, you also can initiate text amendments, map amendments, and so forth. You also conduct the public meetings. I think you already knew that, though. The duties of the Planning Commission, you also have the ability, if you see something in the UDO that has come to your attention, like how did that get in there? That's a question you can ask staff. The Planning Commission as a group can initiate and say, we would like to see staff come back with a text amendment and change this, or maybe make a change to the zoning ordinance. You're also going to be reviewing, and this is again right out of the UDO, you're reviewing preliminary and final plats. You're advising the Board of Commissioners regarding environmental policy, comprehensive planning, community development, housing, transportation, land use issues, and capital improvements. I didn't know that. I don't know if you knew that or not, but if you see that there's some infrastructure, that you get to make that recommendation to the Board of Commissioners under the UDO. And then, of course, you're working with various departments of the county. So,
Can you go back to that slide and just talk about maybe an example when it comes to that of item 3?
well, if you see, so if the planning staff or the planning commission saw an environmental issue, maybe setbacks in the water resource district they thought it wasn't sufficient. They would like the commissioners to look at maybe increasing it by 20 feet, setbacks by 20 feet. They could forward that recommendation to the commissioners for your consideration. Comprehensive planning, sort of the analysis I referenced a little bit ago, looking at the future land use map and saying, wait a minute, this area is not really, has any real industrial development or commercial development. Why not? This area might be good for it. They can make that recommendation to the board. Ultimately, it's up to the board to approve it, but that's what they can do. Those are some examples.
And are these initiated by cases maybe that come before the planning commission that are on the agendas? Or could this be initiated through some other means, those recommendations?
It can be, I mean, you can ask for matters to be put on the agenda. I don't know if you have a time during your meeting agendas where you each can make comments on certain things. You can raise it to your group. I mean, it's like anything else. You have to get a majority of your group to go along with you to actually formulate a recommendation. But one of you can say, hey, I noticed this in this last case. I wish staff would take a look at this and consider making this change. And if 2 more of your planning commission members say, I agree, then that's initiating something to take a look at it. The process itself, planning staff obviously is going to receive the applications. They're going to process it, make sure it's complete, make sure it has the information. The planning commission needs to be able to review it and provide a recommendation to the board of commissioners. The buck stops, of course, with the board of commissioners. You have to make the decision as to whether to approve it or deny it. I know that there's always some reluctance, and I'd have to go back and double check your UDO. I will tell you I see a lot of different zoning ordinances, so I don't have yours committed to memory. Sometimes there are shot clocks, and by that I mean there's a time period in which you have to act. Staff will always advise you as to those time periods. But I don't like deferring things forever, but I also think it never hurts if you have something before you that you feel like you need a few more pieces of information to make a decision, then speak up. I don't think deferring or continuing something one time is going to be a deal breaker. If we're talking about something that's been delayed 6 months, that wasn't the applicant's doing, the applicant didn't ask for that continuance, I think that probably pushes the limits that you don't want to go to. But always feel good about you having the information you need, same with the commissioners, in order to make a decision, okay? Public hearings, this is typically the way they're run. The staff will go first to sort of frame the issue and what's before. The applicant and those speaking in favor go next. The person's opposed. It is essential that we provide equal time. We have time limits in our UDO. State law mandates that we give each side not less than 10 minutes. That's the benchmark. If you want to give, if they have 15 minutes each side, that's fine. If you notice that there's a whole group of people, either way, that you want to allow them all to speak, you can always vote to extend those time periods. Just make sure you do it evenly. In other words, if you think you've got more people in favor, which never seems to happen, I might add. I think I've seen that happen like 3 times in my entire career, where there's more people wanting to speak in favor than against something. In that instance, you can say, all right, we're going to extend it to 30 minutes, but each side will get 30 minutes. Because the one thing I will hear if you don't do that is how they weren't given due process, we weren't treated fairly, they had more opportunities to speak. So whatever you do, whether you're, I mean, you may do it for both sides, and one side may not have more than 2 speakers, and if they only take up 5 minutes apiece, then there's 20 minutes that's left over. It's just the way it goes. But at least your action was to treat them equally, and that's easier for me to defend.
So the extension of time doesn't include the actual presenter for the applicant. It's just for the supporters and the,
I can take that one. So it actually does include the applicant's presentation because they're considered in support of.
Okay.
So when you do equal time, it would be, because sometimes if you notice in your planning commission hearings or the board of commissions hearings, the applicant wants to reserve their time for rebuttal. So it would consider it.
okay.
Of course, the fun is when the applicant wants to reserve their time for rebuttal, but there are other people speaking in favor who then chew up some of that time period.
Absolutely, yes.
So that's where it can get a little bit.
Okay. So what is the easiest way when you have a group of people opposed to it to equalize the time when you have so many people? And we've had that a couple of times.
I always urge the chair to make the announcement that you have 20 minutes per side. I would ask that if you have additional things that we haven't heard of, but please be considerate of the other people who have signed up or are trying to speak tonight. I have seen efficient uses by people who say, I'm speaking on behalf of this group, please raise your hand. And next thing you know, you've got 10 people, that one speaker gets up and says something, but inevitably you wind up with somebody. In fact, I think I was out here not long ago for a meeting where somebody got up and spoke and basically ate up all the time period. And that, it's not always fair to the other people that are there, but we have to set limits. I hate to say that. I mean, these meetings are what the law calls a limited public forum. That doesn't mean that everybody gets to get up and speak for as long as they want to. And inevitably, we're also not typically wanting to still be in here at the public hearing at 12:30, 1 o'clock in the morning, which I have done, by the way, I'll tell you that.
We don't want you to have to do it again. I do remember the time you're speaking about.
I do.
And I think that because I got so enamored with the speaker that I forgot the time clock was not visible. So I just realized quickly, I was like, wait a minute, I think we need to give other people time.
Yes.
So I think we're going to have the clock up there going forward.
For the two chairs, I will tell you, I've seen certain people running meetings who will say, all right, how many people are here to speak in favor? How many are here to speak against? Okay. We're going to divide you up. If there's 10 speakers and they've got 30 minutes, then we're going to limit each person to 3 minutes so that everybody has a chance to speak. So whatever you have to say, that can be an efficient way to handle larger crowds. But I know right now where I live in Coweta County, they've got a lot of conversations going on about data centers, and I think some of those meetings are going on very late. And you're in a catch-22. If you try to run an efficient meeting and not have everybody getting home at 12, 1 o'clock, then you're infringing on their First Amendment rights.
Correct.
But by the same token, what I find a lot of times at these meetings is you have a lot of repetitiveness. After you've heard the first 3 or 4 speakers, you kind of get the general gist of why the people who are here opposing something are opposing it, why the people who are in favor of it are in favor of it. And that's where, yeah. But I also recognize it's a lot easier for the lawyer to do it that way than it is for the people who are actually running the meeting.
Agreed.
I understand. The UDO has the standards of review for the Planning Commission that are set forth. I have them on this slide. I think it just was one slide. So these are the standards that staff will give in their report, and they'll provide you with some analysis as to each standard. Of course, then you're to consider them on your own, based on what staff has presented, what the applicants presented, and what the people in opposition have presented. I'm not going to go through all 8 unless you want me to.
I have a question. I was in it might have been ACCG, I can't remember where, but in some counties, the Planning Commission board members actually meet with the developers and let them tell them, and walk them through exactly what they're doing. Is that appropriate or not?
I'm going to get to this later.
Okay.
I think that public hearing process is set up in such a way that anytime you meet outside of those parameters, I'm going to hear about it later. By whoever's defending you is going to hear about it later. If you meet with the applicant and go through the process, then you sure better set up time to meet with the people who are opposing it. Otherwise, you're going to hear how you are favoring one side over the other. I'm also going to get into this because I tried a case for the city of Brookhaven a couple years ago, and I'm just going to warn everybody, and I get to this. You're going to think you're being helpful. You're going to think you're trying to get everybody a fair and balanced idea. You would be surprised how it sounds or can be portrayed if you're ever asked about it in a courtroom. So I always tell my elected officials, I will tell you that they don't always listen to me, not to meet with applicants, let staff handle it, and keep all your discussions and questions and considerations in the context of a public meeting, because it sure is hard to ding you if you do it that way. The farther planning commission members and elected officials get into the weeds with either side, the more you risk hearing the other side talk about how they weren't given a fair shot. Again, though, they don't always listen to me, and I realize I'm probably being overly cautious, but I really try to protect the people that I represent. So that's why I give that advice.
Perception,
Thank you.
perception matters, I guess that's what I.
Well, perception is a lot of times reality.
Yeah, right.
Yeah, and again, it's hard to make sure that you give everybody equal time.
Right.
That's the point I was going to get back at. So I guess it is very, very important to make sure each person have an equal amount of time, because basically if they have the equal amount of time, we're still in compliance as far as,
Oh, absolutely.
okay.
Yeah.
So if they.
Well,
10 minutes
each side has to have an equal amount of time.
Right.
You have to give both sides the same time limits.
Okay.
How they divvy that up, I have found there are certain techniques that can work, but sometimes they're not going to. I mean, sometimes you're going to have 20 speakers, and if your time limit's 20 minutes, you're either going to have to vote to extend, and even then, you got to put some parameters on it, because again, trust me, I had a meeting one night in Peachtree City that lasted until 2:45 in the morning. My wife called me. I was at the Waffle House getting a very late dinner at 3:15, wondering had I run into a ditch or was I okay? I mean, we all have jobs, lives, other things to do. So the notion of being here till then, I want everybody to have their fair say, but I think they can do it concisely. The job is hard enough without keeping everybody here past midnight. That's my position. It's not always popular, but that's been my position. Anyway, those are your standards of review. If you guys, do you have questions about any of them, or am I?
Why don't you read them?
Okay. First is the existing uses and zoning of the nearby properties. In other words, if everything around this property is zoned residential and they're looking for, or a similar density residential, then that's a compatible use. If they're wanting to put a cement plant in right around a school and a bunch of other low density or medium density residential, that probably isn't very compatible. Second is the extent to which the property values are diminished by the particular zoning restrictions. I'm going to touch on this more later, but let's face it. If you wanted the highest and best use, you'll see this on a slide later. You'll hear the words highest and best use all the time. Like, we deserve to have our property zoned to the highest and best use. Kind of. If we wanted everybody to have the highest profit, the highest margin on their property, we would just zone everything commercial, industrial, and shut it down. They're always going to yield more. But that's not the test in Georgia. The test, and this is my most challenging comment of the tonight, not to sound like a lawyer, is how does your property as it's currently zoned compared to other properties that are similarly zoned? Okay? Now I'm going to say that in English. If you have a piece of property that's zoned R1, is that even a classification?
Yes.
Okay, good. I was hoping I didn't make that up. So if your property is zoned R1 and you're wanting to get something that's a higher density residential zoning, the test is not what your property would be worth under the higher density. The test is, how does your property, is your value as R1 worth the same amount per acre as other R1 property? That's first step of the analysis. Inevitably, you're going to find that a lot of the properties that have the same zoning classification are going to have similar property values. Why? Because if you've got 20 acres, it's R1, there's typically 1 acre lots. By the time you take out your streets, you're going to get 18, 19 houses on your 20 acres. Okay? That's going to be universal. You're going to get something similar on, if it's 25 acres, then they're probably going to get 24, 23 lots. Okay? The next thing is, what's the demand? In other words, and we had this happen with a piece of property that was over off of Sigmund Road. They came in asking for a warehouse. That property was zoned to a low-density residential classification. Future land use map said it was supposed to be a warehouse, or supposed to be industrial zoning. Strike one. Then we did find a comparable sale of R1 property not far from it. Turns out they had bought it on speculation, and they really had no intention of developing it R1. We also found very little demand for R1 zone property at the time. Not saying it doesn't change, because they always change, in Rockdale County. Well, we just kind of dug ourselves a hole that we didn't wind up winning that case. So there's a couple elements. The last element to that, how's it compared to everything else, is there demand? And the last thing that you can never predict is what your site conditions are. In other words, if you have a 20-acre property that's zoned R1, but 10 of those acres are in wetlands or floodplain, guess what? There's only 10 of them that have usability. So that's a problem. Next, the extent to which the destruction of property values of the plaintiffs promotes the health, safety, morals, or general welfare of the public. In other words, if their property is not quite worth the same, but it's consistent with other zonings in the area, then you're not just protecting, you're not just harming that person, you're also benefiting the surrounding property values and uses because it's similar to what's out there already. Did I say that in a non-lawyer way? I didn't think so. Okay. All right, I'll back up. Part of it is the term health, safety, morals, and general welfare of the public. That's a legal term. I mean, everything that the county adopts, every ordinance and regulation is supposed to promote the health, safety, and welfare of all the residents of Rockdale County. That's a legal thing. If we pass a loitering ordinance, it's supposed to promote the health, welfare, and safety of the Rockdale County residents. So it's more of a general, what we call police powers, and that's not law enforcement. There are certain regulatory actions like zoning that a county or a city can take and that fall under this big umbrella of what the law calls a police power. That means you get to regulate that, okay? Am I still talking bad like a lawyer? Okay, see, I'm good. All right. So whatever you're doing is supposed to, if the property values for the landowner are diminished in some way, then it has to be for a greater good. I think I said it better that time.
Getting better by the minute.
Yeah, we're getting there.
Keep going, right?
Yeah. It's also from a case, and sometimes these things just get thrown in ordinances because the Supreme Court of Georgia said this is one of the standards you're supposed to have at your zoning, and none of us really know exactly what they were talking about.
So let me give you an example. So in the past, I learned where we do step-down zoning, meaning that if you have, let's say, commercial on a high-traffic area, and then you might have a buffer between that and the residential, that would be, in my opinion, called step-down zoning. So it might be O&I or another classification, so that you don't have that commercial and all that it brings next to a neighborhood. So is that, I think I'm confused by the word general welfare, which could be perceived a lot of different ways.
Yeah, it can. And I think that was probably done intentionally,
Yes.
that it gives you the flexibility as to what the commissioners ultimately decide is in the best general welfare of the entirety of Rockdale County. Using your example, you see a lot of times where you'll have commercial development, and then you might have some townhouses, apartments, or so forth, sort of next to it. And then the farther you move away, you'll get to larger lot, half-acre lots, one-acre lots. So there's sort of a transition from commercial to your low-density residential.
And I don't know that we have that in Rockdale yet, but, you know, in the in the future land use map, that might be something to think about for step-down zoning.
Yep.
Okay.
The relative gain to the public as compared to the hardship imposed on the property owner. That goes to what I was saying, the next two items, that and the suitability of the subject property for the zone purposes. In other words, if it's R1 property, it might be worth the same as other property that's zoned R1, but again, under my example of you have floodplain and you can't use all of it, maybe that property is not suitable. The other thing you will have is if you have, well, in my example, you've got a road that was just widened to 4 lanes, Sigmund Road. Are you really going to have R1 large acre lot subdivision adjacent to Sigmund Road? There are some as you go down Sigmund Road, but that was one of the things that also worked against us in that case. And back to number 4, what is the gain to the public? You're talking like in your step down zoning. All right, if you're saying, okay, this is for the good of all of Rockdale County to deny this zoning, is it really? And if it is the overall plan or adherence to the plan, how does that weigh when it looks at what the detriment is to the individual property owner? And it's funny because we have these standards, but I'm telling you, I can cite to you 4 cases, and I'm not going to do that, that all go back to the test I mentioned a minute ago. How does a property relate to similarly zoned properties? Can it be developed, and what the demand is for that zoning classification?
And I think as we work on our unified development ordinances in general, we will talk about what that looks like. For instance, if you went from commercial and then next door had a vape store, it would be perceived very differently than a veterinarian's office, right? So, but I think a vape store would be in the commercial anyway, but zoning. But anyway, that's kind of the example I would think of. And when you think about the greater good, one is perceived much healthier in a community service versus the other one.
Sure.
So, okay.
So I think one of the things we hear most often at both the Planning Commission and for us is we don't need any more development, we don't need any more townhomes, we don't need any more apartment buildings. So my question is that something, is that an argument for us to consider, or is that really the onus is on the developer or the person who owns it to consider that they think they can produce something like that? I'm always confused with that one.
That is layered, so I'm going to take it a little bit at a time.
Okay.
Yes, you hear that frequently.
I mean, and
yeah.
it's not just Rockdale County, I hear it
Right.
all across the nation.
And I always want to ask myself, what do you base that on? Has anybody done a housing study and done any analysis of the number of single-family detached townhouses, condos, apartments? There's always got to be an affordable housing component under the Fair Housing Act. Are we able to meet the needs of all of our residents? That's something. I know this with experience with my own children, one of whom's married, and she and her husband trying to buy their first house. As we all know, with the housing market these days, I'm 59. It looks a lot different for that couple to buy a house than it did for my wife and I to buy our first house. And I guess it's all relative. Money's a lot different now than it was in 1992 when we bought that house, but nonetheless, it's kind of daunting to what that looks like, especially when you take into account current interest rates. So I always wonder in my head, okay, what are you basing that on? Is there more traffic? Well, yeah, as things develop, there's going to be more traffic. Is it going to be more concentrated? Well, yes. You have an interstate highway that bisects your county. You have a couple of state routes that run through your county. Of course, development's always going to start there and then kind of work its way back. So in those areas, things get more concentrated. I saw an interesting article in the Atlanta Journal-Constitution. I don't know if anybody saw it, but Bill Torpy, who's an opinion writer, I don't know if y'all ever read Bill Torpy or not, but he had an interesting statistic about the number of Georgia counties 20, 25 years ago where there were more deaths than births. And back 20, 25 years ago, it was like 50 of Georgia's 159 counties. Next year, there will be 100 of Georgia's 159 counties where there are more deaths than births. And that was kind of staggering to me. And what the main point of the article was, sort of the slow erosion of the rural parts of Georgia, that people are either leaving or employers are shutting down. And after reading that article, there was a part of me that thought, well, you know, the areas that are growing, maybe that's not so bad. I know there's a burden that goes with it, although I hear that down my way all the time in Coweta and Fayette County. Traffic, traffic, traffic. My mom lives with my sister up in Cummings, so about once a month or so I'm traversing Georgia 400, going into the Avalon and dealing with what I consider major league traffic. Are there more cars? Yeah. Is it a little bit, are there times that it's slow down? Yes. Every time I come out to visit y'all, I get to visit I-20 and 285 interchange. And it takes longer than I think it should. But then I remember Atlanta's got how many interstates that run through the heart of it. Everybody's shocked that the connector's bogged down. Folks, you've got 2 north-south corridors and an east-west corridor that all kind of come together. Of course it's going to slow down. So back to your point, I don't know. I always wonder what their basis is of that. I don't worry about that as much as I worry about what have we been approving lately? Have we had an overabundance of townhouse developments? Have we balanced that with single-family detached developments that, and a lot of them, we'll talk about this later, you don't see. If they already have their zoning and their entitlement to develop it, then they're coming to the planning commission with their site plan. So you don't know per se what all has happened. Staff would be able to tell you what's been going on, but you don't know. So, but you hear that everywhere, no matter where you go.
Have you seen other communities track that differently? Meaning that, let's say if something was approved 3 years ago, but maybe the dirt's just not, it's not come out of the ground yet, how they might track it and say, all right, right now we've already approved this many permits, and so we're going to hold off on approving any more in this category?
I have not.
Okay.
No. Once they have their zoning and their, then they, and a land disturbance permit, I mean, it's a checklist.
Right.
I mean, it's not,
So
there's no real discretion in it. If they meet all the
Correct.
requirements, you issue the permit.
So for instance, some of the categories we have for consideration would be our schools, our hospital, what else? Let's see. Water and sewer availability, those kind of things. So when we have all those criteria at the time, based on what we have in our community visibly, a lot of times, we might make that decision. But if we take into consideration everything that's been approved that could be built, then it may be a very different situation.
Well, yes and no. I mean, if you came forward with a development in 2007 and you started to move dirt and put in your infrastructure when everything crashed in 2008, you might have said, oh, well, we better not approve more, but nobody knew what was going to happen.
Sure.
I mean, I know a lot of dirt that's in Coweta County. There's one that's just getting ready to come out of the ground with the development for an over 55 community. That literally, they had the streets done prior to the stock market crash in 2008. They've been sitting on it that long. That's the next thing, the length of time the property's been vacant as owned. Well, here, they were just waiting their time. The developer had the ability to carry the property, and they weren't in a hurry to turn it around.
Okay.
So it's not always, there's not always a straight line as to why something is sat, and you also don't know when things are going to develop. Market, the one thing I'll say 2 things. One, I think that the market, if somebody's coming forward with a townhouse development, there are some really smart people who have done analysis that think that that product will sell and do well in the community. They're not in this to lose money. So I always look at that as something I try to keep in the back of my head and not get jaded. I also say that sometimes sewer is both a blessing and a curse. Sewer, if you don't have sewer you're going to have a lot more septic tanks. I don't think that's good for the environment. I like the way the sewer treats the water and it returns back to our creeks and rivers and so forth. Isn't that what the water wars with Alabama and Florida and Georgia were kind of all about? By the same token, I see this in Noonan a lot. You will have developers, because sewer's available, who will go for the townhouse or the cluster home concept because they have sewer, and of course, clustering gets you more density. More density means you sold more houses. More houses mean you're making more money. I don't fault them for that. But then, right outside the city limits of the city of Noonan, as you're going out Lower Fayetteville Road, which I go just about every night coming home from my office, just outside the city limits, there's this gorgeous series of single-family detached residences on 1 acre lots. And the city manager of Noonan one time was like, well, don't tell me it won't sell. It's literally selling right outside my city limits. Well, you've got sewer in Noonan. Sometimes sewer can make people just go for one. And it's ultimately the job of the board and everybody to sort of make sure that there's a balance in your housing stock. Because I think if you can do that, then you're going to give people the opportunity to sort of get what they want. It's not just going to be all the same thing everywhere. Get into 7, we've already touched on that, policies of the comprehensive plan, and then whether existing or changing conditions affecting the use and development of property are present that support approval or denial. I think, again, that's mostly going to be market demand, but more importantly, environmental conditions. I think that's what 8's referring to. But again, these are just sort of, you'll see these same standards in just about every zoning ordinance you look at in some variation. Actions by the Planning Commission. 1, recommend approval. 2, recommend approval with conditions. 3, recommend denial. And 4, you can vote to make no recommendation. It's what I commonly call the Switzerland approach. We're not going to take a position on this one. It does say in your UDO that if 3 motions are made on an issue and no decision is reached, then it is forwarded to the Board of Commissioners with a no recommendation. How are we doing? We've been going at this for about 50 minutes. Does everybody want a quick leg stretch or keep rolling? Okay.
Don't they have to give a reason if there's no recommendation?
No. No. Sometimes I find in my line of work, the less said, the better. Again, when we go to Superior Court, if somebody sues us, we're starting anew anyway. Last thing I'll tell the Planning Commission, and I may touch on this later, so if I spoil, this is spoiler alert if I do. And I also say this to staff. Don't get your feelings hurt if you recommend one way and the Board of Commissioners go the other way. And that's for staff as well.
But why are we here if that is the action officer?
You know something? You're there because you're providing a basis, you're providing your recommendation, your input. I have seen instances where a planning commission will say no or recommend denial, and they'll talk about certain concerns they have. Those concerns are later parlayed into additional conditions that are put on the approval that the commissioners make. And then the other, and staff, because here's what I will tell you how this plays out. Say staff gets an application and they recommend approval. Let's say it comes to the Planning Commission and they recommend approval. And then it goes to the Board of Commissioners and they deny it. Does anybody want to know what's like bullet 3 and 4 in the lawsuit that's filed? Staff recommended approval. Planning Commission recommended approval. Those evil commissioners said no. Now do it the other way, same thing. You guys, it's just, I don't know. I tell everybody, the people who are the elected officials had the courage to put their name on a ballot and let the voters decide their fate. And with that, they get to make the final decision on all this. But I don't want the role you serve. I also have told planning commissions before and staff, you know, sometimes I tell my staffs, don't even make a recommendation. Outline the criteria and let everybody figure it out. Because if you do, guess who they're going to depose? My planning director. And she's going to say, yeah, we recommended approval, and that's Exhibit A when we get in the courtroom. I do recommend if the board approves it, we would recommend the following conditions. I'd say the same thing, that we're recommending denial, but if you decide to approve it, we would like to see these 3 items addressed as conditions. That's beneficial, and that's a good way to get your voice across. You're not saying, hey, we want you to approve it, but we're also saying, should you go the other way, please make sure you address these things.
So when we do make a recommendation for denial, so that goes to the Board of Commissioners. At that point in time, I think is what I'm saying, we also can say, okay, if you do approve it, although we considered that it be denied and voted that it be denied, we want you to take in considerations these type of recommendations that we have listed here.
Absolutely.
Okay, all right.
Yeah.
Okay.
Absolutely. Board of Commissioners, I've highlighted the 2 biggest ones for you. These are your standards of review, and there are 2 pages here, but whether the proposed future land use map amendment would result in a future land use classification that is more consistent with the text and policies of the comprehensive plan than the current classification. That's sort of our exhibit A of, hey, it says commercial on your future land use map, they've asked for commercial. Then B, whether the proposed amendment will result in a land use that is more compatible with the current and future land use of the adjacent nearby property. I will tell you that even in some limited circumstances, you can get into, well, this is how we want it to grow, but it's just not there yet. In about 3 or 4 years, we might have more people on the ground to justify a commercial node in this area. That's something else you can consider. But that's typically going to be your larger acre tracts. Something that would, I mean, there's a difference between a site that can hold a convenience store and a gas station versus a site that a Publix could go into. And then, again, we've got all the different standards. The commissioners also have the added one down in I that talking about negative impacts on the water supply. Schools are a tough thing. I don't generally recommend citing schools. And again, if you get to the point of turning something down, I would just make a motion to deny. I'll figure it out, or whoever's arguing it if we wind up in court. Sometimes the less said, well, they said schools. Oh, darn, I wish they hadn't said that. I know you want to say something, but sometimes just a simple no sort of, and by the same token, a yes sort of carries the day. There are situations where the board will approve something and an adjacent property owner will challenge that. They'll preserve their rights and they'll contest your decision. It's not often, but it does happen. So again, sometimes the less said, the better off. Gives me more to work with. Because they can't get in your head, they can't take your deposition, they can't make you testify if we wind up in court about it. So.
But with schools, that's a moving target anyway, because there's cyclical things that can happen where kindergarten's a very low year and, you know, rezonings and all kinds of things. So I can understand that rationale.
You know, if the school's biggest problem is they need to build another school somewhere, I think that's a blessing in some ways.
Yeah.
It means you've got more families, more younger people, I know, but it's not always viewed like that by the taxpayers, but I'm a taxpayer too, y'all. But I've never.
That doesn't mean they'll always build a new school. That just
I
means you might
understand
have
that.
more trailers.
I understand that. Well, and
As
sometimes
y'all know, I don't like trailers. I mention that at like every meeting. It just drives
my wife's
me
an
nuts.
elementary school principal in South Fulton County, so I know exactly what
Right,
you're
it just
talking
drives
about.
me nuts.
They
But-
had trailers, and then they
Right.
figured out how to redistrict, which is never a popular thing to do when you're a school
Right,
board either.
right.
But suddenly the trailers weren't needed anymore, but the school's still nice and full.
Yeah. But I do agree that less is more. That makes sense.
Yeah,
It's like you said, you can figure it out and you can find the reasons.
absolutely. All right, again, action by the Board of Commissioners. Approve with conditions. You can approve, and this is again verbatim from your UDO, an amendment to include a lesser geographic area or a less intense zoning district or land use category, okay? Say they're asking for an R4. Again, I'm making that up. Well, maybe you don't want it to be an R4, but you'd be okay with it as an R2. Okay. You can do an intermediary zoning. Same difference with different industrial districts, different commercial districts, a heavy industrial versus light industrial, a light commercial versus a really intense commercial. You can always look at, maybe you don't want to go quite as far as the applicant wants you to, and you still may wind up in court, but again, it's a better defensible position if we wind up there. You can deny it, you can refer it back to the Planning Commission to reconsider it, get more information, and then you can defer final action until the next regularly scheduled or special called meeting. Special use permits, yes, sir.
I have a question. So if it's referred back to the Planning Commission for reconsideration, how would that look? We would reconsider it based on recommendations from the commission?
If they're going to refer it back, if I'm Jennifer or Cotter, the county attorney, I would always say, okay, what is it you want the Planning Commission to look at? Don't just send it back to them without something specific, because they've already had a public hearing, they've already considered it and made a recommendation. What additional thing is it, or things, are you wanting the Planning Commission to review before it comes back to us to a final decision?
And just to add one more thing, a lot of times if we recommend that something goes back to the Planning Commission, it's because it's changed too much as it's going through the public hearing process, like the site plan changed or the request changed, and so therefore it needs to be heard again. So we might do something like that.
Yeah, I mean, they come to you with a 256 townhome development, and by the time they get through and it comes to the Board of Commissioners, it's down to 128. Well, that's not what, Planning Commission might have recommended denial on 256, but with 128 and additional review, it may come back with a recommendation of approval. You don't know. So, yeah. Special use permits, again, operate similar to a rezoning of property or a text amendment. It's going to come to the Planning Commission for a recommendation, ultimate decision to the Board of Commissioners. There are the same standards of review for special use permits in the UDO for both boards. In other words, remember we had one slide that talked about your review of zoning matters a few minutes ago, and then a separate set of standards for the Board of Commissioners. For the special use permit, they're the exact same. And they're a little more site specific. The zoning matters are a little more broad stroke, legalese type stuff, but you can see looking at these, you're looking at compatibility, but you're also looking like the third bullet point, adequacy of the ingress and egress, transportation to and from the property. Those are, and also on special use permits, consistency with the wastewater treatment system and the water system as well. And there were 2 pages of those. Action by the Planning Commission, again, you're going to look at it. Considerations are, does the application meet the criteria, the comp plan, and the underlying zoning district? Because again, this property is already zoned. They're asking for a special use that's allowed under that zoning up to the discretion of the Board of Commissioners. And again, sort of similar to what you can do with zoning, you have multiple options. Recommend approval. You can approve it with application of conditions. You can do lesser area, sort of the same thing. So you have different options you can consider. In other words, if they're asking for you to do the special use on 10 acres, you can say, well, you can do it on 6. That's something you could recommend to the Board of Commissioners and the Commissioners could approve. Action by the Board of Commissioners is, again, pretty much similar. Variances we're going to touch on, but not linger on very long, because that's the Board of Adjustments. But I will tell you up front, I realize that variances are necessary. There are times that you have a creek on your property that really impinges your development. And I see it a lot, not with big developments. I see the ones I understand more when it's a single lot and they're trying to put a house on that lot, as opposed the variances that people come in when they're doing a big development. I'm like, wait a minute, you control the site plan. Cut down 2 houses and you can comply. Now, I know those 2 houses have value, but you sort of control, you've got the entire site. Why are you coming to me for a variance? I don't like variances. I'll tell you that up front. Why? Because I'm a lawyer. Because if you got rules and you just follow those rules and not vary from those rules, i.e. a variance, it's a lot easier for me, because what happens are variances get approved and then inevitably somebody says, well, you've established a precedent. No, we really didn't. There's no such thing really as precedent in my mind, because each board is its own board. So a board that approved something 2 years ago, that's not, I mean, it's Georgia law is crystal clear. One board can't bind succeeding boards. Well, if that's the principle of Georgia law that's in a statute, I didn't just make it up, then how can you tell me that a variance that somebody approved that's similar to the one you're asking for now is they're under a duty to approve it? But you hear the word precedent a lot. Of course, if you don't I don't like approving variances because we like it. Oh, they're wanting to put a deck on their back house. Well, I want them to improve their property too. It's not that I'm against that, but is there a way that they can do it that doesn't require you to encroach into your rear yard setback? Please tell me there is.
I got a question about variances too, because sometimes when we are approving large property developments and stuff, and when we always say, okay, if you want 250 homes, they want to modify the setback, they want to modify, certain guidelines that are standards for Rockdale County. And then they modify the standards to meet the applicant needs, because no, I want to develop 220 houses. I don't want to develop 200 houses. If I develop 200 houses, I lose profit. They don't come out and say that, but I could develop 220 houses, and you can provide me with some modifications to my standards, and I can meet that. But, I feel like you do. If a guideline is a guideline, and standards is standards, you can't manipulate it to make profit. And
I agree. By the same token, I always have to balance it in my head, okay? It's a lot easier for me to understand variances if you do have a segment of your property that has wetlands or floodplain that you've got to stay. In other words, there's a certain part of that property that can't be developed. Well, here's the thing. When you go to buy that property, they don't always give you a discount for the unbuildable area. They say it's 100 acres, you're going to pay us X amount per acre. That's the going rate for per acre price in Rockdale County. Well, now your math just got a little bit harder. So sometimes you need that extra 20 houses to make it work. But if it's fairly virgin soil that doesn't have environmental issues, which again, Rockdale County, it's named Rockdale County for a reason. There's a lot of rock, right? Mm-hmm. So sometimes it can be a challenge. And so I think I don't ever say no 100% of the time, just like I don't recommend yes 100% of the time. I think that you have to look at each one on its own merits, but my default leans more no than yes. But I think, that's the best way I can explain it. I'm not going to bore you with these. These are the variances and the standards that the Board of Adjustment has to consider. I mainly put them in, Commissioners, because I know they don't come to you, but I'm sure you're aware and you hear about variances that are approved. There are certain things that you cannot get a variance for. That's actually set forth in the UDO, and I've listed when variances are not permitted. That's what I've covered in these two slides. Flood damage prevention, that is also something that the Board of Adjustments considers. And they also have standards. There were 3 pages of standards. I'm going to touch on this. It's amazing how this thing has evolved. Cell towers. I remember back in '96 when the Telecommunications Act was passed by Congress. Everybody was up in arms.
we don't have that slide. I don't see it slide.
Yeah, I don't see it.
Well, we can get that.
Oh, yes.
We have, there was one version I sent. I added this slide this morning because it came to me on my morning walk. Like, oh, I didn't touch on cell towers. Cell towers back in '96, everybody was up in arms. They were like, oh gosh, they're going to put them in near my home and I'm going to glow in the dark the next day because of all the radiation from the cell tower, which is why Congress said you can't consider health or environmental issues in deciding whether to allow a cell tower or not. So every time people get up and talk about that, I'm always like, well, don't talk to me. Talk to your congressman. Talk to your senator to get that changed. Because they said in '96, you can't change it. It's funny because cities and counties fought cell towers tooth and nail for 20 years. But in the last 5, 10, 15 years, it's gone less fighting about them than wanting them. Why? because everybody has that thing was vibrating in my briefcase an hour ago, and they want coverage. The worst spot we all have is when we're riding down the road talking to somebody and we hit a dead zone. And next thing you know, there's one of those nice, cute little tree antennas that go up, and it looks fake, and you know it's fake, but at least they tried to make it better than the old steel erector sets they used to put up as cell towers. And all of a sudden now, when I'm driving down that road, I don't have that dead spot. I will tell you, we've had one cell tower issue since I started doing work for Rockdale County. I think it was sometime last year. And it was less about the neighbors. The neighbors were all like, hey, our coverage is terrible out here. It had more to do with a title issue in the property. It had been, you had had a lease signed. It wasn't, somebody missed it in the closing or whatever. And so the current property owner was upset about it. The neighbors, I don't think ever said a word. I think it was just the person who now owned the property that didn't know about the lease that the previous property owner had signed with the cell tower. That was the issue. And I even see that, believe it or not, in Peachtree City. I mean, North Fulton Cities, Milton took one case, I think it was all the way to the United States Supreme Court on cell towers. They fought it tooth and nail. So when representing Peachtree City, like I have since 2003, I remember a friend of mine came down with a cell tower, and I just kind of put on my helmet and prayed like, oh, this is going to be a brutal meeting. And there were 9 people that strode to the podium and said, we really need coverage in this area. And I was like, where am I? Am I still? They were excited about it. And they did a good job. It was on a church property. It was kind of blended in with a lot of trees that were left on the site, so it didn't stick out like a sore thumb. But the biggest problem you're going to have is if they have, and they typically do their homework, they're not asking for a tower because they have abundance of coverage in that area. They're asking for a tower because there's typically little to no coverage in that area, and there's nowhere else that they can put an antenna. Because trust me, Verizon would be happy to get money from T-Mobile to put an antenna from T-Mobile on Verizon's tower. They'll take that monthly lease in a heartbeat. They want to have coverage in those areas. And that's why I said in my last bullet point, this topic has truly calmed down. I need to knock on wood when I say that, because just as soon as I say that, you'll have some controversial cell tower issue before you in the next 12 months.
Because in the last 31 years, 15 of them have been that.
What?
Just the expansion of cell towers.
Yeah.
How it works and how the industry's changed. Yeah.
But I think that Peachtree City case, I think they made it camouflaged like a tree, or so that it fit in more appropriately.
Yes. A dear friend of mine with a firm in Atlanta, Ellen Smith. She's with Parker Poe. And I'll never forget, because I called her because the meeting adjourned not long after it got approved, and I was like, what just happened? She goes, I know. My client was just, we couldn't believe it. Yeah.
They have some that looks like church steeples, just to camouflage.
Oh, yeah. It's amazing. They've gotten real creative with them, and they've also, I always thought the first tree one I saw was coming down Georgia 400 right by the Lenox Road exit. And I looked at it, and I was like, it's like when you go to Animal Kingdom and there's that big fake tree when you walk in. It looked just as fake right by 400, but I thought, oh my gosh, that's a cell tower. And they've also come up with microcells now, little things that go on utility poles. They've gotten creative about things. And of course, the most creative thing they've done is they've decided, you know, if we try to put it on this rural area, then some people might be upset if we put it too close to the subdivision. But if we go to the school board or to the county and say, hey, we'd like to lease some space on your property, that's another way they've been smart and targeted and getting buy-in. We have one right now that's coming forward, I think, at some point in the next 6 to 8 months in Peachtree City, where they tried to put it on a school board. School board said no, but there's a city park right next door. So it's possibly going to go there if the lease terms can get negotiated.
Just out of curiosity, the reasoning that legislation came about the health reasons, was it because it was too, what was the reason?
I think it's called a very good lobbying effort. If I'm being honest with you, I think the telecom, I mean, just think about how that industry has changed from 96. I know personally. I think back in 92, 93, 94, my wife and I would share this. Remember the old box phones? We had one of those that, depending on who was going where that day, the other one would take the phone. She inevitably got it about 90% of the time, but occasionally I'd get it.
The bag phone.
Yes, the bag phone.
$2.50 a minute.
Yes, exactly. So, but now, look, I mean, everybody has a phone. And if they don't have a phone, they have a tablet, or they have both. So now they're more worried about coverage than they are. We don't care how ugly that thing works. If I have 4 bars, that's good. Yeah, they're really. And then there's also been some other, I mean, Georgia Supreme Court said basically on utility companies, Georgia Power, EMCs, that those properties are not subject to local regulations. There were a couple of North Georgia counties that got mad at some lines that were going up in Rabun County. And so they tried to stop it, and they put in, a couple counties did moratorium on those. And Supreme Court said, yeah, no. If it's essential operations, they're regulated by the PSC, you can't stop it. Well, I have one cell tower that appeared on Georgia Power substation site in North Peachtree City. And they had, the applicant's attorney called me, and I said, well, under these opinions, there's not a darn thing you can do. Yeah, okay, have at it. And so we told them they were exempt. It was all part of Georgia Power now. It's amazing. The meter readers are gone. I don't know if they still exist out here, but now everything's electronic. They can read meters. You have that cell tower. It basically reads all the electrical meters for Georgia Power in Peachtree City from that area. Now, of course, they put that tower up. What joined it not too long after that? A Verizon antenna and a T-Mobile. There's a couple more antennas on there. But I'd like to think that helps our power rates. I think we all know differently. But nonetheless, the next door neighbors were very mad at me, and I showed them those cases, and they had a lawyer who was a patent lawyer, and I was like, look, if you see something I missed, call me. They were cussing me like a dog in my conference room in my office in downtown Noonan. I never heard from them after I left the offices and read the cases. So, going back to considerations, and this is just kind of starting to circle back a little bit. Staff recommendations, listen to what they have to say. These are folks that deal with it every day. Trust me, they know the ordinances better than I do. They know them better than y'all probably do. I'm just going to guess. The information provided by the applicant, again, they're not everybody's in it. I mean, yeah, their job is to make money. I don't consider that a bad thing. I go to gas stations. They're trying to make money. I try to make money every day as a lawyer. Information provided by those speaking in favor or against. I've heard a lot of redundant comments from people speaking at zoning hearings that I just kind of scratch my head at. But you know what? I've also heard a lot of good comments. There was somebody who pointed out an issue one time on a real controversial zoning in one of my jurisdictions, and I thought, Dad, I've never heard that before, but that's a great point. Guess what happened? They weren't ranting and raving, or they just raised the point, and guess what? There was a condition added to address that issue. Comp plan, we've already touched on that. Surrounding zoning, to me, is a big thing. I mean, if you've got an industrial area that's established and operating maybe putting in a single-family detached residential zoning next to it is not your best idea. Because now you've created a tension where none existed. Now, they might be manufacturing. The people in the residential area are going to complain. It's noisy. I have a baby. The baby's trying to sleep, and somebody was running a saw from 12 to 1. I mean, you'd just be surprised. So what's in that area is important. I really think there's the highest burden that the applicant should have in every case is telling you why the existing zoning doesn't work. And don't just tell me that, well, I'll make more money if you zone it to R4 instead of R2. No, tell me why R2 doesn't work. And you've heard me already say this, not highest and best use. I put down here schools, traffic, and other decoys. You're going to hear about schools. You're going to hear about traffic. I mean, the bottom line is if you put in some developments, the county's going to have bigger tax base. That property's now developed. So if they need to improve the roads, I know that comes at a cost, but that's kind of the way this works. You can also sometimes, not all the time, but sometimes get some road improvements as a condition of your approval. I think you have to be careful with that. It has to really be tied to what they're getting. And even then, I would encourage getting buy-in from the applicant as opposed to mandating it. Causes of frustration. This is just me being as honest as I can be with you. I've already touched on it when I said don't get your feelings hurt. Staff analysis. I can't tell you the number of times that an elected official has said to me, I can't believe the staff recommended approval. Guess what? No offense, sir, but did you go to college? You went to college. Did you study planning? Did you really? I mean, I know you have feelings about things, but have you really gotten an education or had life experiences to lead you to think that you really know what the recommendation? I always tell my planning staff, like, what do you want me to do on this one? I want you to do what your best professional opinion is. Let the chips fall where it falls. Because ultimately, if that person has to testify, they have to raise their right hand and tell the truth, right? I don't want them to say, well, I was going to recommend approval, but the lawyer told me not to. No, I'm not going to do that.
No, you don't.
No, I'm not going to do that. I had that happen in a case I had to defend. We actually wound up winning it. Planning staff had recommended approval, and that was the first deposition the other side took. They're like, what do I do? You tell the truth. I'll figure it out. Public comments. I never diminish. These are your voters, your taxpayers. By the same token, this is always where I walk into interesting waters. The fact that there's 20 people here to speak in opposition to you, you guys were elected. We're in a representative form of government. It's not how many people show up on open mic night or a public hearing to say, turn this down, turn this down, turn this down. No, it's not. Any more than if 100 of us call our local congressman, thank you for your call, but it doesn't guarantee that they're going to go the way I want them to go. Voting, mind your procedural rules. You've got Robert's Rules of Order, whatever ones you've adopted. When you're voting on stuff, if you have to unwind something, you can unwind it. I mean, motions for reconsideration happen. I touched on this earlier. Is the area ready for a change? Like, okay, your comp plan says this is what I think you're going to have happen. There I go wandering from the microphone again. I'm sorry. If your comp plan is saying this is how we want it to develop, it may not be quite ready yet for the zoning that's on the table. By the same token, if this is how the Board of Commissioners has said they want this area to develop and that's in our plan, it has to start somewhere. And where you inevitably see this rub is in your more rural parts and somebody wants to do the first subdivision in that area. I think we all know that they're not always going to stay rural. We'd love for it to, but it doesn't always stay the same. Things change. This is the low-hanging fruit, the easiest parcels with no environmental constraints, they always go first, every time. There's not a creek, there's not a setback that's going to chew up the property. The rock isn't bad under the ground. Whatever you want to name the environmental issue might be, those properties always go first. What you wind up last are always your infill or your problem pieces. Lawsuit I tried for Peachtree City in the late, probably 2009 time period, was the last lot developed in a great subdivision in Peachtree City. Do you know why it was the last lot? Because all the stormwater from the greenbelt flowed directly onto this property. And nobody bothered to pay attention to that, so of course the house was getting flooded, and the greenbelt was city property, so guess who got charged with creating a nuisance? The city. So they're always going to be your infill parcels. If you went out there now and found a piece of dirt that hasn't been kicked over on Highway 138, I can guarantee you there's a reason why. And somebody's going to want something a little bit out of the ordinary because nothing else can go there. Permits versus rezonings. Again, a rezoning is a legislative act. You have a lot of discretion. It's not unlimited, but you have discretion. Permits that staff typically handles are, normally it's more checking the boxes. special use permits and conditional use permits. Again, you have a little bit more discretion on the special use. Conditional is a little bit more if you meet these criteria. That's the way most zoning ordinances are set up. If you want to reference the criteria, okay. I still don't mind referencing nothing or being as general as possible. It's easy if you have, say you have a staff report that recommends denial and the planning commission recommends denial, and you make a motion that says, I make a motion we deny it based on the information provided today and in the planning staff and the planning commission actions. Okay, you just had a nice broad stroke. Don't get too far into, well, because of this or that. Planning staff and commission, their recommendations, I've already touched on that. I tell everybody this, whether you're on the planning commission or the board of commissioners, count your friends the day you start, especially the elected officials. If you still have that number when you come out of office, consider yourself lucky. You will have a lot of people who suddenly want to be your friend. Why? I hate to sound so cynical, y'all, but I've seen it happen too many times. I had one mayor one time that suddenly got quite enamored with all the people he was going to dinner with and playing golf with and everything else. And the day he left office, nobody would call him back. And he was devastated. And he was like, you tried to warn me. I tell every newly elected official I get with, people are cozying up to you for a reason. And the day you're done, you're going to be really disappointed if you start thinking. I also say if you're having a conversation or if you're saying something in the minutes, how will it sound in court? And I tell you that because that's what I do. And you'd be surprised how it can sound in court. I always tell my elected officials, and planning commission, same thing. If you have questions, route it through staff. If you look at something, you know, you get your agenda package and you're like, I have a question about this. Let staff know. Say, hey, I'm going to want an answer to this question at our meeting next week. Let them be your filter to get the information, or at least give the applicant the information that, hey, one of the commissioners indicated that they're going to want an answer to this question. It just is so much better when you're not the one with your fingerprints on it. Staff, by that standpoint, if you get a request, you don't have to say who asked for it. Just say, hey, one of my planning commission members, one of my commissioners said, hey, I have a question about this. Let them know they're going to get asked it. If we get to a meeting and one of you asks a question, it'll become obvious. But I always find you letting staff do that work is just easier on everybody. Am I done?
I think that's it. Wait,
Wow.
all right.
Am I under?
Yes, you've done a great job and we're happy about that.
Well, I have a question.
I'm speaking next week at the City County Attorney Seminar on contracts, and I have the 45-minute segment right before we go to lunch.
Oh
My goal is to finish in 35 minutes. I can guarantee I won't go 1 minute past 45. I will stop mid-sentence because I am not depriving a whole group of lawyers of their lunchtime.
Good idea.
Talk about pitchfork yielding mob, that would be bad. So I've done a lot of talking, and we still have time left. Who has questions?
I just have a question, and this could be clarified if I'm mistaken. Sometime when we deny something here, we're asked to state as to why we denied. But you just said don't state as to why we denied. I just want a clarification. What's our process? Do we state why we deny something in particular, or we don't need to state why we deny something, or either approve something, you know? Yeah, I'm just saying. What?
I know there's on one occasion where we did ask, you know, to emphasize why you denied it. I think maybe 2 meetings before.
But that is that. So that's. I'm just asking because when we're thinking up here, you know, like he just said, make it general, and just say, you know, and make it general. But are we going to be asked to state as to why we may approve or deny it?
So
how's that?
I'd like to weigh in right here, if that's all right, Director Gardner. So as far as it relates to the Planning Commission, I know some of the times we will ask as staff for the Planning Commission to let us know why they want to deny, because that could also result in a condition that could be placed on the application or something for the board to consider. So if there's an application before you and after you've discussed it and you've heard the presentation, perhaps you do want to deny it, but then as staff, we may say, okay, so I hear that you want to deny, but are there other things that you could elaborate on so that we may share that recommendation with the Board of Commissioners, because it could result in additional conditions or something like that for the board to consider what you might have been thinking when you were issuing the denial. Does that make sense? Because it's, I think, I want to put words in your mouth, but please, please weigh in, Ted, because there is a distinction between what the Planning Commission recommends and what the Board of Commissioners inevitably decides. And knowing your input and your recommendations so we can turn around and give that to the board. Now, when Mr. Meeker was talking about rendering decisions, when it comes to the Board of Commissioners, it's better what goes on the record if they don't get too much into the denial. So that's more the legislative piece he's talking about with the Board of Commissioners. But with the Planning Commission, the more information that we have as far as a recommendation, the better we can share with the board. Does that help some?
Well, and let me just say that sometimes when I look at things and see that the Planning Commission has denied something, I'd like to know why, because I'm not seeing anything. Mm-hmm. And so, I think because I assume that you have all done your research, you've listened, and you have a reason for denying something, that I would like you to share that with me.
So those will be minutes that are kept within our record too, when we go back to our minutes as to why each individual denied it too.
And in fact, all of it is part of the record. So if someone is, not only if they speak, but also if they send emails or any kind of other correspondence, we keep that as a matter of record too.
Okay. Because my thought process when you saying questions and stuff, if we present the questions to the staff, I think sometimes it's good if everybody has the same question that
Absolutely.
we're asking. Mm-hmm. Your audience, your public, because it could be mindful for them too. Could be something,
Mm-hmm.
if they change their mind as to why,
That's right, and it kind of goes back to when we were talking about when there might be occasions where there might be a recommendation for the board to send something back to the Planning Commission, because as you know, we go through a 2 public hearing process, right? There's something that's introduced to the board for a first read, and then that is sent to the Planning Commission to consider for consideration, and then to the Board of Commissioners for their public hearing, and then on to a second read in front of the Board of Commissioners. And along that way, a lot could change. It's possible that the discussion that was had at the Planning Commission could look different by the time it gets to the Board of Commissioners for a second read. And so making sure all that information is considered is being fair and equitable. And so we have to take that all in consideration when we're looking at these things as they're going through the process. So, good point.
I'll tell you a funny anecdote. There's an old saying that goes, if there's one lawyer in town, that lawyer will starve. If there's 2, then they have each other to argue with, so they'll both do well. I say that to say my advice might be different than other people's. And I recognize, I don't know that there's one 100% uniform way. I think of it in the mindset of, I'm going to have to go to court and argue it.
It makes sense to me.
So the less ammunition that the other side has from minutes, the more I like it. Because now I get to fill in the blanks with my witnesses and the testimony they provide, okay? As opposed to them pointing to, well, this person said this and this person said that. So that's a little bit different mindset than somebody who's city attorney but not going to court, or county attorney and not going to court to have to argue all this stuff. I like sort of having my own blank slate. I'll also say I hold you to a different standard than I hold the commissioners. So in other words, you ask your questions, you state some reasons. Again, it's good information for them to have, but it's not binding on the county. It's just a recommendation. It's an important recommendation, don't get me wrong, but it's a recommendation. The final action rests with the commissioners. So in other words, if you talk a little bit more about your why than the commissioners do, I'm not going to have any heartburn over that. But it's like anything else, I'd still be measured to the biggest extent you can.
I have a procedural question. If we vote and the vote is tied, and as the chairman, I can refrain from voting. I don't have to vote. That's correct, right?
There's nothing in Georgia law that makes somebody cast a vote.
So it'll just end up a tie.
Right.
Okay.
Yeah. But I always recommend, though, that if that's where the board is at, that somebody can make a follow-up motion. I would just say we move this forward with no recommendation.
With no recommendation.
That's what I would do.
Okay.
I always like to have some affirmative action, even whether it's denial, approval, or no action, that there's at least some vote on record, and the commissioners will be able to see it. They'll see your minutes, and they'll be like, okay, well, there's a motion to deny or a motion to approve, and it didn't carry. The chair didn't cast a vote, so it was tied 2-2. Then somebody made a follow-up motion to forward it with no recommendation. Again, though, either denial or no recommendation, I would still include a couple things, like, hey, no recommendation, but we want the commissioners to pay attention to these two factors or these two things. You're at least dropping a nugget that, I don't know how you're going to vote on this, but we'd at least like to see you address these concerns.
Right.
That the citizens raised, or that staff raised, or that somebody was, or that you yourselves thought of during the course of the meeting.
Doesn't he only get that one time a year? I'm just kidding. But one thing that I wanted to point out is that when we do have these hearings, that it is good for every member to go and see the property in question and what is under review.
Yes, if it's legislative.
Okay.
So for conditional use permits and the Board of Adjustments on variances, I would say no. And here's my reasoning.
Okay.
You're quasi-judicial. Think of it as I go to court and I see opposing counsel coming out of chambers with the judge, and they've been talking about my case. That's called ex parte communications. If you're rendering a quasi-judicial decision and you go out to the property, I mean, I tell my elected officials, if you want to do a drive-by, okay, but don't stop, don't roll down your window, and if he's out in the yard trying to wave you down, because
drive and see the property.
because if that next door neighbor is diametrically opposed to whatever's being sought, and you're there yucking it up in the driveway,
No,
then
that's not
you've
right.
just had what they would consider to be an ex parte communication. So keep your communications, yeah, if you want to do a drive-by, that's fine. But I wouldn't stop and talk to anybody.
Right,
'Cause-
correct.
Well,
Any
can
more-
they call us and say, Bill, can you go out and take pictures of this for me?
Absolutely. I can do that.
Thank you.
So the consideration is not necessarily contained to what's presented to the commissioners. So for instance, in court, if you're presenting something in court, that judge doesn't need to go see the crime scene unless both parties know about it. You see what I'm saying? So it's sort of like, I guess my question is it contained to what's presented to the board? And maybe some of us, it's a small county, so some of us just might happen to be really familiar with the property.
Yeah.
We can take that into consideration.
Right.
Or, I mean, should we keep that extra knowledge to ourselves?
If you're familiar with it,
Yeah.
based, on previous, I mean, I remember one that I was surprised. Somebody had a variance request, and it was a house I was at a party at 18 months before for watching football games. And I was like, oh gosh, I'm really familiar with this. We all have our basic lives and stuff. So yeah, you might bring, hey, I'm familiar with this parcel. Here's why. I've not been out there since the application was filed, and they had no discussions with me. But here's why this is a little bit more of a challenging piece of property than you might think. If you've got that knowledge, then you're certainly welcome, because we all bring our personal knowledge to it. And unfortunately, we have our good and bad biases at times too. That's just part of being human.
Anybody you have any other questions or anything else for tonight?
No, I was going to see if there's
Okay.
any more comments. Commissioner Williams?
Well, so I really appreciate your coming and talking about this because it just refreshes everything. Even though I've been doing this for a while, there's still stuff that I need to hear again and again. So thank you for coming.
Thank you for inviting me.
I agree, this was very informative and appreciate it.
All right.
Learned a lot.
I think it'll all settle in with the reread of the copies of everything. Like, okay, what was he really saying? Just kind of reading through it and stuff. But it's great information. For me, we are relatively a new planning group here. We have a few individuals, or an individual that's been here for some time, but it's just incorporating all of this in the same learn. But then the conversation of like, what did you get from this? Just kind of understanding each other's interpretation of what you presented today is going to be the fun fact finding for me. And seeing it all in action. Be like, I'm sorry, can you present your recommendation? No, I'm just kidding.
See, already using it. See, there you go.
I
did
like
not-
that we all got the same information.
Yeah.
We have to be on the same page. And so
I agree.
this is really important because we all got the same information. So when we hear up here, we all processing from the same information. And like you said, I've been here for a minute, but every director handles things differently. Oh, you want me to tell me? I just said I did not. I don't know. I have to give a reason to deny. So, it's just different. For everybody handles things differently. They process or, how they want things done differently. So it's good.
One of the things that kind of stands out to me is the recommendation to move forward without a recommendation. That is key, because sitting here, you hear a motion to approve or deny, and you're sitting here like, okay, let me think through it again. Okay, approve. But then when you leave, it's like, should I have really approved or denied that? So knowing that we can stand on the gut of yes or no, and then give a few bullet points of why, just makes me feel better about the whole process.
Your input's invaluable in that. I know, that's why I said, don't get your feelings hurt. You'd be amazed at how many times decisions rendered by advisory bodies really pay dividends down the road, especially in the denial, but then the elected body approves it. But they take into account what was said and the conditions added. I've seen it in action, and it's really good.
We had I won't get specifics, we had a case last time or so of what some individual wanted to do in his own property. And I was like, shoot, I can't do that to my property, because I was planning it in my head, like, this is what I would like to do for the deer. And I'm like, oh, man. So you won't get a request from me.
Now, I would just like to say the planning department is very helpful and very knowledgeable. So we are really blessed to have that information. It's very, coming in new is like, I don't know a lot of this stuff, but just being able to ask questions and so making themselves available, I really appreciate that.
One thing is coming from living in subdivisions, right, where everything is cookie cutter, and then I moved to Rockdale and there's like trees and things on my property. I remember when I moved to my location, I moved my parents in with me, and I needed to have an electric fence, a gate for my mom, so because she couldn't get in and out of the car to open the gate up and stuff. And I'm with EMC, but I needed to have approval from the planning for them to put a power box on a pole that was on my property so I could have a gate that's a quarter mile off the road. I'm like, what? I didn't get it all, but it all makes sense now.
And I deal in the worst case scenarios. Comes to me, it's always, oh gosh, something went wrong. But we had somebody that added a meter on their house. And they said they needed it for this reason. And the council approved it, and I said, it's going to be a duplex. It was single-family residence. Well, sure enough, they subdivided, and in a single-family residential area, It was now a duplex. And council was like, "You were right. We should have." Yeah, they don't need a second meter on a standard house,
Unless they're doing something illegal.
or unless they're planning some workaround.
Maybe so.
I'll leave you with two comments. One, there are times, I will confess, that due to schedule, I'm not as prompt in my responses to planning staff. I'm just going to go ahead and confess that. But generally, I think I'm fairly responsive, quickly. Sometimes better than others. I am human. If you have questions when you get home, I always have that happen. I'm riding home. Lawyer has 3 arguments, one on the way to court, one in court, and one on the way home. You're going to think of questions tonight or tomorrow. Oh, I should have asked them. Send them to staff, they'll write them to me, and I'll get you an answer. Last thing is sort of my ongoing speech, not to get on my soapbox, about civility. I will tell you that probably the best council member I've ever represented would oftentimes be the one in a 4-1 vote or one of the 2 in a 3-2 vote. And inevitably now, if that happens, that person who's in the minority says, well, I voted against it, but they didn't go my way. This one would have people come up to her after the meeting and say, well, at least you didn't vote it. And she stopped them in the tracks and said, no, I'm a part of council. I may have voted against it, but council's vote was to approve it. I'm a part of council. Therefore, even though I didn't vote for it, I support council's decision. It seems to be getting rarer and rarer in what I do that I see that anymore. It's more shock politics and everything else. I would encourage y'all to do that, because the person you're a little bit frustrated with today might be your biggest ally on the next one. So if you sort of keep that in the back of your head as you go through things, don't burn bridges, that person will be a good support for you going forward. So there's my little soapbox, and now I'll shut up and start heading back to Noonan.
Thank you.
Thank y'all.
At this time, I'd like to call the meeting to adjournment. Do you want to also close yours out?
I also call the meeting to adjournment, Planning Commission.
And thank you to our citizens and staff members who've been here with us tonight. Thank you. Thank you. Now.